Good afternoon, everyone. My name is Kristen Solis. I'm one of the mentor attorneys here at the Dallas Volunteer Attorney Program. And for those of you that are not familiar with DVAP, as we affectionately call it, we are a joint program with Legal Aid of Northwest Texas and the Dallas Bar Association. And our primary mission is to match low-income Dallas residents with private attorneys that will work their case pro bono from start to finish. We take a wide variety of cases, but one of the types of cases we do fairly regularly is will drafting. Will drafting is actually probably one of the easiest ways to get your foot in the door and start doing pro bono cases. There is such a need out there for it. So here today we have Brandy Baxter Thompson to talk to you about how to actually draft the wills. Brandy is a partner at Land Smith, Sosolick, Baxter Thompson, and Johnson. She's board certified in estate planning and probate law, and her practice is dedicated to estate planning, probate, trust, guardianship matters. She's got extensive litigation experience and extensive experience in estate planning. She got her Bachelor's of Arts from Austin College in Sherman and her JD from Texas Wesleyan, which is now Texas A&M, graduating in the top 15% of her law class. She's clerked for the Chief Justice of the Second Court of Appeals. She has been one of our mentor attorneys in probate law for years, and in 2018, she received the DVAP Ken Fuller Outstanding Mentor Award for her services for DVAP. She has been recognized by her peers for years as a Texas super lawyer and just so knowledgeable about estate planning. So if you have questions during the presentation, please put them in the Q&A at the bottom. And if we have time at the end, then Brandy will get to them then. But without further ado, I will turn it over to Brandy.
Thank you, Kristen, for that introduction. I really appreciate it. We are going to talk about how to prepare a will, but there's several things that I want to talk to you about that you need to think about before you even start drafting the document. And we've got a PowerPoint presentation that's going to come up, and we'll just work through that. So you don't have to look at me throughout the whole presentation. And I think Maricela is going to pull that up. Do we have that?
Okay. Give me 1 second.
Okay, very good. And so just know that what we're going to talk about are the basics. I will get into some things that are not necessarily related to drafting a will for DVAP, but they're things that I think you should consider if you're going to be drafting a will for a non-indigent client. Typically the type of person that's going to come to DVAP and be vetted for services, they're not going to necessarily need a trust, but there are some things to consider.
Oh, Brandy, I believe you went on mute.
Oh, there we go. Even for an indigent individual, simply because they may have minors, or they may have, the possibility they may have somebody that's incapacitated, etc. So, all right. So, am I able to proceed with this, or?
I will be moving the slides, but you can go ahead and present.
Okay, if you'll go ahead to the next slide. So the first thing that you want to do when you meet with your client is make sure that the person you're meeting with is the client. One of the things that those of us that deal with litigation see a lot of, and what results in litigation, is having a person who has been unduly influenced to prepare the will or other documents. Unfortunately, there's a lot of elder financial exploitation. We have in Dallas County, we're fortunate enough to have the Elder Safety Center, which is a collaboration between the DA's office, the senior source, and the probate courts, which kind of extols that this is a big problem. So the first thing you need to do is when you get that phone call is make sure that the person that's calling is the actual person that is going to be hiring you to take care of the estate planning. It's not necessarily improper for someone to call on someone's behalf. They may be blind, they may be hard of hearing, which doesn't necessarily render them, mentally incapacitated, but it makes it difficult for them. So whenever I meet with somebody, I have somebody calling for me, I always ask that, I need to meet with them in person. I can't start drafting any documents before I actually talk to the client. When you are meeting with that person and they have somebody that helps them, and I just had this the other day. I had somebody come in and she's had her daughter-in-law bring her, but her daughter-in-law sat out in the conference room and was not a part of the conversation. Had no idea what we were talking about. And just was perfectly fine. And I've had other situations where it's a little dicey. And so I think as an ethical rule, if you do suspect exploitation, you should contact APS. If you believe that the person may not have capacity and is being unduly influenced, you may also need to make a referral to the probate court. So the next slide. When you have a married couple, you should take care to include a waiver of conflict in your engagement letter. It sounds odd that a married couple would necessarily have a conflict, but they could, and that's something that you have to address in the very beginning. You can't have a meeting with a couple and then they leave and one of the spouses calls back and says, "Oh, I've got this child that my husband or my wife doesn't know about, and I want to make a provision for them, or I want to change, do a different will than what we talked about." I mean, those are all things that are, could be conflicts or are conflicts. And if you do find yourself in a position where there is a conflict, you just will have to tell both people that you can't represent them anymore. When you have a married couple, you want to make sure that you collect in any prenuptial agreements or partition agreements that you will need to draft around, and ask them about their prior marriages. Do they have any children? Is this a blended family? And additionally, are there any prior divorce decrees that are in play that you might need to look at to see if there are any obligations with respect to maintaining a life insurance policy, or providing that a certain assets go to the divorced spouse at death. It doesn't happen that often, but it's something that you definitely need to check the box on and make sure that you've looked at. The next slide. And I always like to throw in my little cartoons. And I love this one. It's a little less amusing when you hear your kids calling it the death tax. And obviously, none of the clients that we're going to be talking to through DVAP we're going to have to deal with the estate tax issue. But and if you do find yourself in that position, you need to make sure that you have sufficient background and somebody assisting you with making sure that you're drafting things properly. Next. So once you've determined that, you have this client that is, your client, they're able to communicate with you, there's no issues with capacity. The three things that you need to think about are, gathering information from the client, and going through the different points of discussion. And then we'll also talk about, the formation requirements in order to make a will. What does it take to actually make the will? Next. All right. So of course, as you probably know, when there's a will contest and there's an issue with um, somebody challenging capacity, one of the elements of capacity is that they know who their family is. And so that's one of the things that I always go through is asking them to give me, a list of all of their family members, the contact information for them. You want, obviously, if they're married, you need to know their spouse's information. If they have children, are any of those children minors? Do we have any special needs children? Do we have any adopted children? This is a time when you're going to delve deep into somebody's family history and finances, et cetera. And it's you can't be afraid to ask these questions, even if they seem delicate. You have to know these things. You have to go into these things. And I'm not going to tell a lot of war stories, but I will tell one that I met with a lady and had her give me all the information about her children, and we prepared the will, and we were in the will signing, and I went through who her children were, and she made some comment about a son that I had never heard of, and so we had to stop the will signing and kind of dig into that a little bit. And so even when you ask, sometimes it was a weird situation. Sometimes they're just not forthcoming. So having multiple calls, multiple meetings is a good thing. It will help you cross-check all of these things. Some people are going to want to treat stepchildren and adopted children differently. Some people will want to treat adopt grandchildren that are stepchildren or adopted differently. And when you're asking about their grandchildren, I always, if they're minors, do they have special needs? We don't want to be leaving, a big asset to, children that are minors. And there's maybe a need to have, some trust language in there so that if the parent dies and it passes to the grandchild, are we going to, make sure there's a trust so we don't have to deal with a guardianship? And you might very specifically ask them if there are any estranged children or grandchildren, so that, that you kind of make sure that you're not leaving somebody out. Next. Obviously, if you've got minors or special needs, children, grandchildren, family members, you need to determine whether or not they already have a special needs trust set up for them. Is there a way to transfer assets to this person outside of what is in the context of their specific will? There may be a way to do that without having to set up a separate trust. And I usually ask for that because a lot of times people, at the end of the day, they don't want to have 4 trusts for the same child. And it may be that you can contribute to that trust, but if you'll need to dig into that and find out if there are. If you have someone that wants to make a gift to a class of individuals, make sure that you identify all of those individuals in the beginning of the will, where you identify all the family. You do not want to just say simply, I'm going to leave everything to my nieces or my nephews, because the court, and at least I've had this happen in Dallas, they will require that you have a determination of heirship to determine who those individuals are. With respect to charities, you want to always include the charity, the proper name for the charity. Some people will want to leave it to, let's say the ASPCA, the national arm for the ASPCA. They may want to make sure that it goes to the local SPCA. All of those entities have their own name, and sometimes they have their own, designation or how they want that identified. I typically like to include not just the name, but, find an address as well. So it makes it really clear, that we want it to go to the SPCA of Dallas, located on Lone Star Drive in Dallas, Texas. And again, even if they're not going to, especially if they're not going to leave anything for a child or grandchild that would normally take under the laws of intestacy, I always identify those children and grandchildren, and that you should very strongly consider having language in there that they understand that they are not leaving anything to this individual. They don't necessarily need to get into the specific reason why, because sometimes that's delicate and they don't want to put that in there. But you want to document that. If you have an individual who doesn't want to leave anything to a particular child because that child stole from them, get the facts about that, get as much backup and documentation as you can, because the chances that child could contest that will later are pretty high. And those of us that handle litigation would very much like, in defending that will, would very much like to have that backup to understand why that child was cut out. Of course, you also need to identify the assets. That's another element of testamentary capacity, that they understand what their assets are, what they own. And with respect to real property, I always make sure and check that they don't have anything outside of Texas. Because if somebody owns oil and gas, or land or a home outside of Texas, that's a whole different animal, and that you really need to consider a revocable living trust to transfer that property to, in order to avoid probate in multiple states. Ask them about their personal property. Do they have any collections or valuables? Some people, if they do have collections or valuables, they may have it insured. Obtain a copy of the the appraisal or the insurance paperwork in order to specifically identify that. You want to go through all of the cash and securities, identifying the accounts and the account numbers. That's not information you're going to need to put in the will, but it's very important to make sure that whenever the client is indicating to you who they want their assets to pass to and how they want them to pass, that the beneficiary designations comport with what the will says. So if the will says, I leave everything to Susie, but then all of the assets or cash and securities, and all of those pass to Johnny, well, that's a conflict, and that's first of all, it's not going to carry out their wishes if they really want it to go to one person. Another issue that you may run across is they may want to set it up in their will to leave it all into a trust, and but then they leave everything to them individually through beneficiary designations. Again, that's not carrying out their wishes. There's a conflict there, and a lot of times people will go to their banks or their brokerage firms or whatever, and they just give them these pieces of they gave them these documents to sign to name a beneficiary, and they just fill it out without even thinking about it. So that's definitely something that you want to double check. And I try to get copies of the forms where they've designated the beneficiaries, so that I can confirm, what they're doing is going to match with what we're doing with the will and other documents. Safe deposit boxes are, I guess fewer and fewer people have them, but when they do have them, you definitely want to make sure that they know what's in that box. It's really helpful to have a list of the items that are in the box. And additionally, I really discourage clients from putting wills in safe deposit boxes. There are banks who will not be named that are extremely difficult to deal with in gaining access to a safe deposit box. Some of them are multiple court orders in order to get into the box, and you just don't want to have to go through that. The only time I've had clients recently say they're going to put it in the box and it seemed okay with me is that they did have another person designated that could enter the box, and they had confirmation that person could enter the box after their death to retrieve documents. And then, of course, if they have any interest in any privately held entities, LLCs, FLPs, it's corporations, etc., you want to obtain copies of those formation documents, because you need to see what do the documents say about what happens at that person's death? Is there somebody that has a right of first refusal to buy that out? Is there going to be, are they in partnership with somebody? How is that going to work? Is their spouse going to step into their shoes as a partner? That's something that you need to talk with your clients about and talk through so that they think through some of these things. They may have really great documents, but if they conflict with what their privately held entities documents say, then you're just kind of setting them up for a big challenge after their death, and you don't want to put their spouse through that for sure. Real property, I've kind of covered some of this. Obviously, trusts are good if you've got property outside of Texas. You want to make sure that you understand whether the property is co-owned. Another thing too to consider is and most people will tell you this, but just, making sure, especially if they're elderly, make sure there's not a reverse mortgage on the house. If there is, then you need to look at the reverse mortgage paperwork and understand, they can't, what's going to happen at their death with that property. And then also explaining homestead rights. There's still a lot of people that don't understand that if the property is a separate property of the spouse that's passing, their surviving spouse still has the right to live in that property the rest of their life. And I try to discourage leaving the interest in the house to children, especially if they're the children that are not of that spouse, which is typically when that happens. But that may be their only asset, and that may be what they want, is they want to make sure that it goes to their kids. But there's things that you can consider. They could put, potentially maybe put it in a trust. Make sure that if you do have a trust, that you have the language in there that permits the surviving spouse to hold it in there and maintain their homestead rights. But those are all things that you need to talk about with your client and really have them think through. When a client asks me to do something that just sounds a little off the wall, or I can see, a few steps ahead of this as to where this could go litigation wise, I question them about it. I ask them, why do you want to do that? What are you trying to accomplish? Don't just ask them what they want. Dig into it a little bit and see what's underlying that, and see if there's a way to kind of accomplish their goals in a way that's going to avoid any conflict after their death. With respect to tangible personal property, most of the time those are things that are given either as a specific bequest, or we have a memorandum in the will that says, or there's a provision in the will that allows for a memorandum that they can specifically identify items to give to specific family members. And, once those things are distributed according to the memorandum, then anything that's left can be distributed, to a single person or to a group of people, or can just be directed to be sold. I've already covered the accounts. Again, just make sure that you understand who's getting those accounts at their death and how those are designated. I've already discussed the safe deposit box, privately held entities. We've kind of covered all of that. But in addition to what I said about formation documents, also go and checking on their status under the Secretary of State is good. Making sure that it's still a viable, entity. And I also try to get copies of tax returns, just to kind of shore up my documentation. It's a whole lot easier especially if they're a single person. This is really important, because when that person passes away, if they don't have a spouse and maybe they just have a niece that's coming in from Florida to probate their will, they don't necessarily know the universe of assets. And so having tax returns will help them, point to various accounts, if there's any interest paid from those accounts, and if there's any reporting from the entities, or there are separate tax returns being filed for those entities. It's going to help the person that's going to be named as executor to know what tax returns are they going to have to file, who's a CPA, who should they go to make sure that this is being taken care of. Gathering the information, we've kind of covered this, identifying the beneficiaries, who are are they going to leave it to family? Are they going to leave it to charities? And making provisions for their pets. Those are the three areas to focus on. Everything I have, son, I have because your grandfather left it to me. I see now that was a bad thing. So not real happy about that. Next. All right. All other things that you need to consider gathering from your client: trusts, premarital partition agreements. There may be trusts that they're the beneficiary of that they didn't create. They may have a trust that their grandparents created or their parents created. You want to check those documents because they may have a power of appointment. A power of appointment is the ability to appoint assets in a trust to somebody else. Typically, a limited power of appointment may permit them to appoint the property in the trust to any descendants of the person that created the trust. So if mom creates a trust and you're representing the child who's an adult, they may have the ability to say, well, I want it to all go to one of my children versus another child. You want to check all of those things. You want to make sure that you understand what kind of power of appointment it is and how it needs to be exercised. Some powers of appointment can be exercised during their life through a deed or just through a document where they direct who gets the assets. Some are required to be exercised through a will. And so if they do have a trust where they have a power of appointment, you need to talk to them about what that is and what that means and whether or not they want to exercise it. Premarital and partition agreements are really important to review and understand and talk to your client about. They may have done the document a long time ago, and they may even want to revoke it. I've had that happen where they decided, we don't necessarily want to do, honor this anymore. We want to do something different. The bottom line is to understand, are there any obligations in that premarital or partition agreement that you have to take into account in the will? Have they waived their right to a homestead exemption under the premarital agreement? Is there a requirement that the surviving spouse move out of the house within a year? You want to talk to them. Or is this still what they want to do? Are these wishes they want to continue to carry out? And if they do, how does that comport with the will that you're drafting for them? Companion animals. So that's one of the conversations that I'm a big animal person. And I love having this conversation with people because it's, people that have pets and they're important to them. It's really good to talk to them about how they thought about, what's going to happen. They may have somebody that has agreed to take the animals at their death. I've had some clients that want to make sure that their pets go to the Stevenson Center at A&M, which they can, for a specific dollar amount per pet, reserve a spot for the pet. And then the pet will be taken down to Stevenson Center and live there for the rest of their life and be taken care of. Sometimes they may want to leave a gift outright to an individual to take care of the pet. Sometimes they want to leave it in a trust and say, I'm going to donate X amount to this trust, make a gift of X amount to this trust. And then once the pet is deceased, then whatever's left can go to the person that's the caregiver, or it can go to, which don't necessarily recommend, but sometimes that's what they want to do. Or maybe they want to leave it to the SPCA or Habit, Operation Kindness, etc. There's a lot of different pet organizations that they could consider if that's something that they're interested in. Of course, other things you've got to discuss with them is who is going to be the executor. And that really starts with the conversation of what is an executor? What is the job of the executor? Who would they want to be the trustee if there's any trusts that are created, and whether or not they want to make any specific bequests. And then the ultimate, of course, is the contingent disposition. If everybody dies, who gets the assets in the estate? When discussing the issue of an executor with the client, you want to get at least a couple of alternates. You want to make sure that you have, their name, address, age, occupation, and make sure there's not any red flags. You're going to have to ask them if that person has been convicted of any felonies. If they want co-executors, explain to them the pros and the cons of that. Some parents are just adamant that all of the kids be co-executors, and others are fine with just appointing one child to take care of everything. You need to, explain the pros and the cons of both of those situations, and dig into the relationship amongst the children. Do the kids get along? Now, granted, a lot of parents will tell you, of course, all of my kids, they get along great. They love each other. You just dig a little bit deeper into that, because sometimes they do to a certain degree in front of mom and dad, but maybe there's some issues with that. Asking where they live also is important, making sure, is there somebody here that's close that can handle everything, rather than having, a child that lives, far away out of state, or that has a type of job that's not going to allow them to do it. If the child works at a bank or a financial institution, a lot of times they'll tell them that they can't be an executor, because they feel like it's a conflict. So you want to make sure you have all of that understood. Discussing whether or not they want to compensate the executor. Most of the time when it's the child, they do not want to compensate the executor. If it's not the child, if it's a friend or someone of that, someone else, then discuss with them the fact that this is a lot of work and it's going to take a lot of time. And, that's not something that, that's something that they should consider. And if they still don't want to leave compensation, that's understood, but at least you've had this conversation with them. With respect to tangible personal property, I always go through how are they going to divide everything? How is the executor going to address an issue of, Susie and Johnny both want grandma's, chair. How is that going to be determined who gets it? And then also making sure that you can allow for a non-pro rata distribution. That just makes the executor's job a lot easier. Of course, if there are any trusts that are created, and such as a contingent trust or a minor incapacitated person's trust, they need to discuss who is that going to be. And it gets a little complicated, because a lot of times what will happen is, if it's a child, let's say they have, 2 children and each child has 2 children. If the son dies, leaving 2 children, who would be in charge of that money? Is that going to be the surviving spouse? Or is that going to be the surviving sibling? And they really need to think through how that's going to work. If they get along really well with their daughter-in-law, for example, they may be fine with that. If they don't trust that person, or they think they're a spendthrift, or that they're not going to really do what's best for the children, then having their other child be the trustee may be something that they want to do. But talk to them about the relationship. If it's not a lot of money, it's really hard to get any kind of financial institution involved. But if we're talking about a significant amount of money, then I very much discourage people from having a family member be in charge of the money. It creates very different dynamics. It makes it difficult, and it can also, kind of challenge the relationship. do you want to have a requirement of the person being bonded? That's not something that most people think about. And I think a lot of estate planners don't do this. They don't include this language in there. But if there's going to be an individual in charge of, $700,000 or $800,000 and they can't get a bond for $700,000 or $800,000, then that's probably not who you want in charge of the money. And so having that conversation with the client is always good. Specific bequests, when I talk about that, we talked about the memorandum of personal property that we can include in the will. That's pretty common. You'll see that in a lot of wills. I think it's probably, substantially in more wills than it's actually used. It's pretty rare that I've run across a memorandum of personal property, but it does happen. If they are going to do a memorandum of personal property, it's good for you to have a copy of it if they decide to do that. That way you can make sure it's with the file. If you retain the original will, keeping that with the original will, make sure that that gets to whoever is appointed as the executor. When you are talking about specific bequests, make sure that they, have thought through what they're giving and how they're doing it, and that it's clear. I had one case that I worked on where the woman that died had actually gone through the trouble of, she took pictures of what she wanted to leave to her stepdaughters, and it was invaluable. It was, it was done by her. She wrote, notes on the photos, and it was grouped together, and it was, really, it was very helpful for everybody to know very specifically what she wanted to do. So if you have a client that has that, if it would warrant that or would even lend itself to that, then having that put together is really a good idea. Obviously, with real property, if there's specific bequests of real property, they need to understand that, if they sell that property before they die, then that person's not going to get the money from that sale. They're only going to get the real property, unless they, of course, provide otherwise. But that's, if they sell the property and then they go put it in a bank account that's POD to somebody else, well, then it doesn't matter what the will says. The POD is gonna override that. And then, of course, talking about mineral interests. If there are any mineral interests, if they know of any oil and gas interests, do they want to include that in the gift of the real property, or do they want that to go to somebody differently, or do they want it to go to multiple people? So the one thing that I think is really a disservice to the client is to have the very ending contingent disposition go to their heirs at law. People go through the time and effort and spend the money with you to prepare a will. They do not want to ultimately have to deal with things going by intestacy and having that be the ultimate distribution of their assets. I think it's really, really important to talk to them about charitable disposition. What do they donate money to now? Do they have a profession that would lend itself to donating to, a specific organization? Is there their alma mater where they went to college, where they went to, even high school? Is there some fund out there that they would like to leave the assets to? And I've had a lot of success with clients doing this, and I think it's, when you explain to them, look, everybody that you've named in this will, everybody, if they're all gone, you want to, make sure this gets into the hands of somebody that's going to utilize it, and not somebody that you don't know at all. And really, you have the power and to do that through making this contingent disposition. If they are still charitable minded and they don't have a specific charity, consider the United Way. Making suggestions of different foundations around town. There's a lot of great organizations in Dallas that make gifts to multiple organizations. So if they don't have anything in particular, you might consider suggesting that as well. All right. So now we're going to talk about just the specific will requirements. Texas Estates Code provides that a person who is of sound mind may execute a will as long as they're 18 years old, or they've been married, or they're a member of the armed forces. So the main thing here is that they're of sound mind and that they are over the age of 18. Will must be in writing. It must be signed by the testator in person. They can have somebody sign it on their behalf. And typically, if the person is, like I mentioned earlier, if somebody's blind, or they've had something happen, physically where they can't, write their name, you might consider having them make a mark, but they can technically ask somebody to, as long as they have the capacity, direct that person to sign on their behalf. The will, if it's in writing and signed by the testator, it must also have two witnesses. And the credible witness definition is that that person is a credible witness if they are not a beneficiary under the will. So they have to be somebody that's not going to take under that specific will. If they do, then that witness is as if they did not sign it. The witnesses have to be at least 14 years of age and subscribe their names to the will in their own handwriting in the testator's presence. Of course, holographic wills are still valid in Texas, and if a person writes out the will and it's wholly in their handwriting, it doesn't have to be a witness. They can, put today's date, write out who they want their assets to go to, and then sign it, and that's a perfectly valid will. One of the holographic wills that I probated a couple of years ago, it was literally he was a doctor. He had a doctor's pad. He wrote out, "I leave everything to my wife," and signed it. And that was it. And we probated that will. It was perfectly valid will. Next. Of course, you've heard of the self-proved will, and what that does is it establishes that the will was properly executed, that the witnesses in the testator, that the testator had capacity, the testator was over 18, the witnesses were over 14, that the testator understood that he was making a will and asked the witnesses to sign, and that they did sign, and that they saw him sign and saw each other sign. And so that's that self-proving affidavit that you can attach to the will, and you can actually attach it after the will is signed. So you can do a will and have it just the testator signs, two witnesses, and then come back a month later and do a self-proving affidavit and attach it to the will. Most of the time, it's all done at the same time. And I will tell you, you probably know that there's a provision that allows for this alternative form to the self-proving affidavit where it's all done in one page. I used to do that, and I stopped doing that. And the reason I did is I like having multiple signatures from the witnesses and from the testator, and that can come in handy in litigation. So just do it however you want, but I like having a separate self-proving affidavit attached to the will. There's a form that you will find in the code, and it's, you can just copy and paste that directly from the code into your wills. And again, they have the separate self-proving affidavit, and then they have the language where it's all combined into one page or one paragraph. As I mentioned, the self-proving affidavit, it approves the will and avoids the need for the witnesses to actually come into court to testify. That way, when the person passes away, the executor, the person named in the will as the executor, can go into court and go through, the testimony that they need to get appointed, or their qualifications, and basically just prove up the will to the extent of saying that, when they passed away, that this is their will, it was never revoked, that, there was no other will made after that will, et cetera. And it simplifies that process after they pass away. As I mentioned, there's the in lieu of the self-proving affidavit, there's the simultaneous self-proving statement. And that can be found in section 251.1045. There is also a provision, I say new, it's probably been in there several years now, but that allows for the person to designate an executor. So if the persons that are in the will either can't serve, won't serve, or are unable to serve, then you can have a person that says who the executor would be. And that just adds another layer of providing for an executor without having to have the court appoint somebody or having all of the beneficiaries agree to somebody. The person that they designate may serve only if everybody is unwilling or unable to serve and that they are not otherwise disqualified. All right. Independent administration, this language here it's imperative that it be in your wills in order to have an independent administration. We're pretty lucky in Texas that we have this very simple language that we can include in our will, and the estate can be administered free of court supervision. It's a significant cost savings and time savings for the clients. And I think the default obviously is that this language be in there, but just make sure that you have it in there and it's tracked exactly like what the code says. Some points to remember, of course: identify all immediate family members, including anyone that's excluded. Don't include social security numbers. And then I always include dates of birth, especially if I'm identifying them as a minor. That way, if the will, 15 years goes by and that person's now 20 something, it's cleared by looking at the will that their date of birth would put them at being an adult, and so there's no issue. And then, of course, you want to make sure that you state whether the children or grandchildren include or exclude stepchildren or adopted children. I've seen a lot of times where they will identify as their children, these are the children, these are my birth children, and these are children that I've adopted, and I want them to be treated, or my stepchildren, and I want them to be treated the same. Other things to consider, of course, I mentioned the non-pro rata distributions. That's really imperative. That makes the executor's job so much easier. Consider how to resolve any disputes over the distribution of tangible personal property. A lot of times, the easiest thing to do is just say that the executor gets the final say. You always want to include a power of sale. And discuss with them, if it's not in there, then we have to go to court and get permission in order to sell property, or you can ask the court to include that in the order. It's easier just to put it in there. And also, I think giving them the permission to sell the tangible personal property, so that they don't have to necessarily distribute it, that they can either sell it, or they can abandon it, or they can donate it. I always like to include a definition of what incapacity is. That's not necessarily what the definition is in our code, but that person that's the executor can make that determination, and having it include people with substance abuse issues or mental health issues. People with substance abuse or mental health issues, they are not necessarily going to be declared incapacitated by a court. They probably won't meet the legal definition of incapacity. But if you give your executor the authority to decide that person shouldn't receive their gift outright, then you're adding another layer of protection, especially when you're talking about, leaving assets to someone that's, or potentially somebody that at this point is very young, who maybe 20s, 30s, or whatever, at the time that they actually receive the assets. The testator may not know that they are going to have, an issue in the future, of course. So making provisions for that is always a good idea. Just real quick, codicils. Basically, codicils are amendments to wills. They have to be executed in the same manner as a will, and they, typically republish the will. If it's something really simple, then codicils are great, especially if you have really long wills. Maybe you just want to change the dollar amount of a gift. Or you want to change, who you want to give a gift to, or an executor, et cetera, those kinds of things without having to redo the whole will. Clients typically like that, but be careful of getting into too many codicils. At some point, it just makes sense to try to just redo the whole will and incorporate all of the changes, so that you're not having to look at 5 different documents in order to determine what is the testamentary intent of this individual. You can tell this was written a couple of years ago. I don't think most of us, knock on wood, are having to deal with this much anymore, but I think we did learn some things, about sanitizing and, being mindful of clients. I mean, I still have some clients that, if they're sick, even not with COVID, they will wear a mask, and it's just a good practice, actually. The remote notary, I have found that to be very cumbersome to obtain. I don't know many people that actually utilized it, but just note that is not something that you can use for wills. And then, of course, trusts do not require witnesses or notaries. So that's something that you can, have the client do to minimize their exposure to other people. All right. So just the last things: ask lots of questions, listen carefully, confirm everything that they tell you with documentation. That's the best way to protect yourself. A lot of times people think they know what a document says or what it means, and they really don't. And so you want to make sure that you understand it and explain it to them, especially if they have a very different idea about what it is than what they've told you, or what actually it says. Be a counselor to your client. Be wary of the helpers. Make sure that anybody that is assisting the client is not in the room, that they're not on the phone, that you are able to really, speak, with your client and understand what their wishes are without them being prompted, and make sure you ask them, for capacity issues. Ask them open-ended questions. Don't ask them questions that just elicit a yes or a no. If you have any concerns, I would also say, make sure the person has been evaluated. If you have really serious concerns, or they're making a pretty significant change in their estate planning and they're elderly, you want to make sure you are covered by having a doctor say that they have the ability to make these decisions. A lot of times, clients will want you to keep the originals. I don't recommend that unless you've got a really good, fireproof, fire safe for that. You don't want the liability, and you might want to even check with your malpractice carrier. They may ding you if you are keeping originals. So the best practice is to, scan them, retain copies electronically and physically, and return the originals to the clients. All right. Let's see here. We've got a couple of questions. I would not attach a copy of any insurance coverage to the will. I don't think that's necessary, and I don't think that would be the best thing to do. Just making sure you have that in your file is the best practice. I'm not aware of any statutes regarding videoing the will execution, you know, it's kind of interesting. There's a difference of opinion. If you talk to estate planners, just strict estate planners, they think, you know, that it's never turns out well to video the will. Of course, from a litigation standpoint, sometimes it's great because, you know, it can either be really, really helpful or it can be really, really bad. And I would encourage you to go out and Google Mary Ellen Benson, Bentzen. Mary Ellen Benson was a woman who owned a home, lived in a home on Swiss Avenue in Dallas, and she in a very deathbed, literally in the hospital bed in Baylor, executed a will that cut out her daughter, and the lawyer videoed it, and it turned out to be a really good thing for the people that were attacking the will. But it's, you know, it's not always a good idea. A lot of times they just don't turn out well, and there's so many things that you can say or do in a video that can be twisted against you. So it's probably not a good idea to do that, but there are no rules or statutes prohibiting it or requiring it. I think we've got the presentation available, and that's the same thing as the outline. So those things can be provided to everybody. If anybody have any other questions? All right. Well, thank you so much for your attendance, and for if you have any questions about anything else, if you'd think of something later on, you're more than welcome to send me an email. My email address and my phone number are both in the PowerPoint presentation. I'm happy to talk to you about any of that.
Thank you, Brandy, for that wonderful presentation. And thank you for everyone for tuning in this afternoon. Please self-report your MCLE course credit using the course number 174-188-316. Again, that is 174-188-316. And the course number, along with a copy of their presentation, will be emailed to everyone following today's presentation. And I believe no additional questions. So thank you, Brandy, for your time. And we hope everyone has a good rest of their afternoons.
Thank you.
Thank you. Bye.